Okay, we're going to start this unit 5. It's the real estate brokerage activities and procedures. You'll see 12 questions on your exam. 12% of your exam comes from this section. Okay, so let's jump in. So the first thing we want to talk about are brokerage offices. How do they operate? How does this work? So active brokers must have an office registered with a DBPR. Okay, the brokerage office must be in an enclosed room, a stationary construction. Brokers must keep records in the office. An office may be in the broker's residence. You have to verify the zoning and HOA laws prior to that. You can't just put it in your residence. You have to. It has to be approvable to do that. Okay. They may have offices in another state, and sales associates may not open and register an office of their own. So a sales associate cannot have their own office. The broker has to be in charge of the office. Now, a sales agent can have an office in their home, but they cannot bring clients there and they can't advertise it as an office. Okay. For tax purposes, they can have a home. So when they say an enclosed room, it could be within another building. You know, it could be in an office building and just be an office suite. In that case, and then the records must be kept in the office. That's digital or paper. Okay. All right. Now, branch offices. Okay, brokers must register each branch office. Okay, a branch office registration's not transferable to another location. So, for example, my office is here in Jacksonville. If I want to move this office to Fort Lauderdale, I can move this license because it's my main branch, right? If I want to move the school, I can move it. If I have a branch office in Orlando, I have this office in Jacksonville, a branch office in Orlando, and I want to move that to Fort Lauderdale, you cannot move that. You have to void that license, and you have to apply for a new branch license. Branch licenses do not move. Main office license move. Good?
Got it.
Now, there's also something called temporary shelter. And that's not a branch office unless sales associates are permanently assigned or sales transactions are closed at that location. That's like when you have a development and they have a trailer outside because there's no buildings yet. And it's like, you know, for people. Now, if there's just information given and no one's assigned to work there and there's no deals done there, it does not have to be a branch location. If there are deals done there and there are people assigned to work there during the day when people are looking at the homes, it is now a branch. You need to have a license for that. Okay. Now let's talk about office signs. You'll see this. There's questions on this. Now, office signs are mandatory. And depending on your office, the sign you have to put up is determined by the rules. So if you're an individual broker and you work under a trade name or under a sole proprietorship, what has to be on the sign is the broker's name and the words following. It has to be licensed real estate broker, or it can be abbreviated. It can say LIC period real estate broker. So just like you see on the screen here, you know, this is his DBA, Little Mo's Realty, right? Little Mo Realty, Merle H. Crawford, licensed real estate broker. So the trade name, this is his DBA, if it's a sole proprietorship, right? Or just an individual. And then the name of the broker as it's on their license. And then it can say licensed real estate broker, or you can have it abbreviated, LIC period real estate broker. Okay. Now, let's talk about the associates' names on entrance signs. Okay. Names of sales associates and broker associates are optional. You do not have to have everybody's name listed on a sign. Just the broker of record, just the qualifying broker must be. Okay. Now, if the names are included, they must not appear misleading, false, or deceptive, or fraudulent. It has to be the actual name. You can't put deceiving names on there. Now, let's talk about brokerage entity sign. Now, a brokerage entity is different than a sole proprietor or a trade name. It's going to be a LLC, a corporation, you know, a partnership, an LLP. When you're an entity, like for example, Pier 21 Realty is an LLC. So my company is an entity and I'm the qualifying broker for it. My company would be this category. So the category before is if it's a sole proprietor or a trade name. That's the only time those other rules matter. These rules matter on every other setup. Okay. So if the brokerage entity is a partnership, a corporation, or a limited liability partnership, the company sign must contain, you have to have the name of the firm or corporation, name of at least one active broker, and the words licensed real estate broker. Okay, you can't abbreviate it. The abbreviation is only on the other one. You can't put the LIC, not on this one. So for example, you look at my sign on my front door. I don't know if you remember that. If you saw, like when you came by, I don't know if you saw the sign on the door.
I saw the sign. I don't remember exactly what it says, but I saw the
Pier
sign.
21 Realty LLC, and then my name, and then licensed real estate broker. Is
Not
exactly
abbreviated.
because
Okay.
by law that has to be there. That's a violation if it's not.
Mm.
Okay. So let's talk about advertising. Now, this is critical, very, very important. Anyone who advertises or claims to be providing real estate services is acting as a broker. So when an agent designs an ad, business card, runs an ad in a newspaper, they're representing the broker. The broker is liable for that. If they mislead it or do something wrong, the broker's in trouble as well. So every broker must approve all ads and logos and things that are done prior to advertising. So advertising must inform people that they are dealing with a licensee, if they're dealing with a licensee or a brokerage firm. Again, like I just said, the broker is responsible for all advertising. So if an agent runs a bad ad, the broker is responsible. Okay, and it must include the name of the brokerage firm in the ad. The name must be there for the state of Florida. Let's talk about team advertising. You know how there's teams and a team of group of for this agent or this broker and that. So team advertising has become pretty critical and really important because there's been a lot of complaints. So the name or logo used by one or more licensees who represent themselves to the public as a team or group. Okay. The team concept allows broker associates and other sales associates to join forces to serve a wider group of customers more efficiently. Teams must advertise in the name of the brokerage firm. So you can't have misleading logos and misleading ads because the public had complaints that, they thought these people owned their own brokerage, but it was under another brokerage. There's been problems like that. Okay, so when you have a team, there's other things that are now required. Okay, the team must file with the employing broker the name of the licensees who the team designates to be responsible for ensuring the team advertising complies with license law. So if there's a team, there's got to be one person who's designated to represent the advertising, and they have a duty to make sure it's all compliant with the broker. The registered broker must at least monthly maintain a record of the members. So if the team has people come and go and leave and come, every month they got to have a new list of who's there and who's not. Somebody quits, somebody leaves, somebody comes back. There's a lot of maintenance there. And you got to have this kept for record because if you get audited or there's a complaint, you're in violation. So the team name and ads must be no larger than the name of the registered broker. So they must have the logo and information for the broker. They could have the team name there too, but it can't be bigger. It's got to be the same size or smaller. The broker's name has to be the biggest or equal to it. Does that make sense?
Yeah, it does. It does. It does.
Okay, so team advertising rule applies to all forms of advertising by the team. Everything. If it's internet, if it's newspapers, if it's flyers being handed out, everything. All forms. If it's business card, everything. Okay. So, as I mentioned, there were complaints. There were complaints about, people misled and thinking the teams were different, not working for the broker. So recently they put together a list of words that cannot be in a team name. And these are the words. So you have agency, associates, brokerage, brokers, company, corporation, corp, Inc., LLC, LLP, LLP, partnership, properties on properties or the word property, real estate or realty. So these words cannot be in a team's name. Now, if you look around on the internet, Facebook and things, you'll see some of these words being used. And it's a matter of time till these people get hit with a violation and a citation, so if they're found. So let's talk about a blind advertisement. Okay, so what's a blind advertisement? This is an advertisement that fails to disclose name of the brokerage firm and includes only a PO box, telephone number, and or street address. Blind advertising is illegal. It cannot be done by a licensee. Okay, so advertising must be worded so reasonable people know they're dealing with a real estate licensee. It has to, real estate license, real estate broker, your license number, on your advertisement, or your brokerage name, who you're working for, right? Advertisements must clearly reveal the license name of the brokerage firm. It must be very clear. Let's talk about personal information advertising. Okay, licensee may use their personal name in ads, provided they include their last name as registered with the DBPR. So whatever their last name is on their license, it must be in the ads. Okay. The yard signs and classified ads must include the name of the brokerage firm. Promotional materials must include the name of the brokerage firm, and the sales associate's name must also appear, or may also appear. It doesn't have to, it may. Promotional materials are pens, like pens, and you have the broker's name and an agent's name, or different magnets, or little trinkets, keychains, things like that. Must have the broker's name and could have the agent's name, which it should, right? Yard signs and classified ads must have the name of the brokerage. So if you see when people have signs, the broker's name is always on there, then the agent's name is a little smaller, and then the phone number for the agent. Number doesn't matter. Does that make sense?
It does. It does. It does.
The last name must be in it no matter what. And promotional items must have the broker's name and the associate's name as well. Okay. Now let's talk about false advertising. Okay, false, deceptive, and misleading information in advertisement is illegal. It's a second-degree misdemeanor. You need to remember that. False advertising is a second-degree misdemeanor. Licensees cannot use an association's name or designation unless currently a member in good standing. That's like you cannot say you're a realtor if you're not a member of the National Association of Realtors. That's false advertising. It's a second-degree misdemeanor, and you lose your license for that. So both the broker and sales associate can be disciplined for false or misleading advertising. So if a broker has an agent who runs a misleading ad and the broker doesn't know that ad's being run, it's not approved, the broker can be penalized and charged with a second-degree misdemeanor if that happens. That's why it's so critical that every ad is approved for the broker. I put a policy in. I had an issue where someone ran an ad without an approval and I had the wrong logo in it. It wasn't a big deal. I mean, the logo it's not illegal, but I wanted the right logo in it so it's compliant with all 3 states. It wasn't intentional. It was a logo I gave them, but I gave them a new one that has to be in. And I, made it clear that it has to be done. So now though I have a policy. If somebody runs an ad without my approval, they're fired that day. They're no longer working here. I don't care who they are, because I'm not going to have any issues like this, if that makes any sense. Like I removed them that day. So that's how that works, because it's not worth it. It's not worth risking this for anything,
Yeah, makes sense.
So internet advertising. Okay, now on the internet advertising, the point of contact information is the means, including the brokerage firm or a licensee, including mailing address, street address, email address, telephone, and fax number. The broker's name must appear adjacent to or immediately above the point of contact information. So like if you look on my website, I have the logo right up top, but on the bottom in the footer, it has everything. The logo, the address, the email, the phone number, everything is in there. All the websites, all the disclaimers. I have everything in there that's compliant with all the states I'm licensed in. So it covers everything. And you have to do that, because if somebody makes a complaint, just like the situation now, what I was just telling you, somebody made a complaint about a fence on a house, blah, blah, blah. You never know. People, they don't like you, your competition to them. They'll look for this stuff, make a complaint, and cause an issue for you,
Makes sense.
So you don't give people a chance. So licensee selling property by owner. Okay, so a licensee who wants to sell their own property by owner. So say you have a house, you want to sell it on your own for sale by owner. You don't want to list it or put it on the market. You can do that. Okay, you can advertise the property and include your personal information. To reduce liability, disclose that the seller is licensed before negotiations begin. So before, like if you want to sell it and advertise it, you can do whatever you want as a normal person. But before you make negotiations, you got to let them know so you have no liability. I'm a licensed real estate agent, right? You through email, through documentation, you document it. You can put it on the contract, whatever. Okay. Telephone solicitations. Okay. Initiation of a call for the purpose of encouraging purchase or investment in property, goods, or services. This is something we do. Making cold calls to obtain listings or buyers is telephone solicitation. It's regulated by state and federal laws, and the calling hours are restricted.
From 8 to 8, I think, right?
Mm-hmm. Go ahead.
Yeah, so from 8 to 8, is that right?
8 to 8 is the time. Yep.
Got it.
I'll go over all the details with you. Yep. For a test, though, and it's this. You don't have to worry. So, or actually, 8 to 9. It's 8 to 9. Federal and Florida. Here's the breakdown. So Florida law, and you got to remember, federal law supersedes Florida law, right? So you have Florida law and you have federal law. So you can be in trouble with both if you break the law. So Florida law says there's no sales solicitation calls registry. So there is a do not call list. The calls are restricted from 8 a.m. to 9 p.m. The list is administered by the Department of Agriculture and Consumer Services. There's a for sale by owner exception. So if somebody's selling their house for sale by owner, there's an exception. You can call them. Federal law supersedes state law. But now what that means is federal law, there's no exception for sale by owner. So if you call it for sale by owner, it's okay in Florida, but it's violating federal law. So if they're on the federal do not call list, you violated it. If they're on the Florida, you didn't violate it. So, it's a catchy thing, right?
It is.
Now, federal law. There's a national do not call registry. The calls are restricted from 8 to 9, the same. You have no exception for sale by owner. You must check the registry. Florida list is added to the national. So when you have the national list, the Florida list is within it. So it's not like you have to look at two different things. For my brokerage, our company we use for our leads already scrubs them. So we know if it tells you do not call, there's a red do not call on them on our system. So you see, do not call this number, do not call this. It tells you on the software.
Gotcha.
So what are some of the exceptions to a national do not call list? Because there's some exceptions. So when you're representing a potential buyer, you may call a for sale by own seller to provide the buyer's interest in the property. So if somebody's selling a property and I have a buyer for it, I can call them up and say, hey, person, I'm a real estate broker with blah, blah, blah. I have a buyer who's interested in your property. Would you be willing to pay me a commission if I bring them to buy your property? And if they do say yes, you do a commission agreement with them and you take them. That's an exception. You may contact individuals with whom associate had an established business relationship for up to 18 months after. So if the sales agent bought a car from a car dealer last month, they can contact that car dealer for up to 18 months because they transacted with them without being violating the law. And you may contact the customer for 3 months after a business inquiry. So if somebody calls you about selling their house and asks you questions, you can call them back for up to 3 months from that date if you have a record of it. And if they're on a do not call list, they can't report that because they inquired from you. Okay.
Gotcha.
Now let's talk about email advertising. The Can Spam Act. Okay, that's what the act is called, the law. Okay, and you have to include a valid physical postal address in the email. You have to provide a way to opt out of email and honor requests within 10 business days. So You ever notice when you get spam emails or sales on the bottom, it says opt out. And if you opt out, they must legally take you out within 10 days. If you get another one after that, they're in violation of this. And if that's reported, they're in violation. You have to clearly indicate that the person or the business sending the message, who they are. So you have to know exactly who they are. You can't have a misleading message. And it must include the domain name and email address of the company. That's required. Fax solicitations. I mean, not many people use fax anymore. But there's something called the Junk Fax Prevention Act, and there's FCC rules to it, the Federal Communication Commission. The requirements to send fax advertisements are, it has to have a date and time the fax is sent, the registered name of the company sending the fax, and the company phone number sending the fax, and an opt-out notice. All those things have to be on a fax if you're sending it. Okay. Now let's talk about escrow accounts and trust accounts. So when you're a brokerage, some brokerages have escrow accounts where they hold the money, or a trust account. Okay. Now, an escrow trust account, it's an account for the deposits of money that the broker holds in trust for others. So if somebody's putting a deposit down, that money would be put into a trust account. Now, it's optional though. Brokerages don't have to have that. Like, for example, I as a brokerage do not have a trust account. I don't have an escrow account. When we put an offer in, there's a title company and an attorney, and we have them hold the escrow, because there's a lot less legal liability and a lot less process. And you're going to see that now. I'm going to teach you all about this. Why there's so many disadvantages around advantages to having that. Okay. So an escrow account is the account for the deposits of money that the broker holds in trust for others. An escrow account is also the account an attorney holds for the same reason. Okay. There's also trust accounts and escrow accounts. So a deposit, what's a deposit? That's money delivered to a licensee in connection with the real estate transaction. An earnest money deposit can be cash or anything that can be converted into money if the seller accepts it. Okay. What are acceptable depositories? You need to know this. For those trust accounts or those escrow accounts, there's only certain types of depositories that the state allows you to put them in. The broker held escrow accounts must be in one of the following: a Florida commercial bank, a Florida credit union, or a Florida savings and loan association. Okay, there are the three places. A Florida-based title company or a Florida attorney broker is not the escrow agent. Okay, the escrow agent would be who's holding the account. A lot of times, a title company does hold it in escrow. The lawyer holds it in escrow. Sometimes the title company is, but you could have an escrow agent hold the money and have a different title company. You don't have to have the same person. The money can be held in a different company. Your lawyer can hold the money. You can have your lawyer hold your escrow, and in the day of closing, they wire it to the title company. Okay. So go ahead.
Sorry, could you repeat that?
Yeah.
The whole company not being the escrow and all that.
Right. So an escrow agent is the person responsible for holding the deposits until closing.
Sure.
An escrow agent can be the broker if they have an escrow account. It can be the buyer's attorney. It can be whoever the buyer chooses, like that has an escrow account. Or they can also use the title company they choose. They can have the title company hold it as well. It just depends on what they choose.
Okay.
So what this is saying is the Florida-based title company or attorney is not the escrow agent unless they choose that. Now, you can have a separate attorney hold it, and some people do that. Okay. Or the broker can hold it if the broker has an escrow account.
Okay.
Okay.
Got it.
Now let's look at the word immediately and how it's defined in the contract. So there's times in the contract where the word immediately is used. Okay. So for sales associate and broker associates, immediately means delivered to the employing broker no later than the end of the next business day. So if somebody gives you a deposit on Thursday, it's got to be given to the broker by Friday at 5. If you get a deposit Friday, the next business day is Monday, right? So by 5. So you must deposit it at the latest the next business day by 5 p.m.
Okay.
Normally you should deposit it the same day. And a lot of times now in the industry, people wire money directly. There's no deposit. It's wired. And then you get a receipt. So a lot of times people aren't given money or checks anymore because it's just wired in from banks in today's world. Okay, now immediately for brokers is different. So if you get a deposit, the deposit must go in the broker's escrow account or in the title company or in the lawyer's account no later than the end of the 3rd business day following receipt by the brokerage. Okay. Does that make sense? So if the brokerage gets the deposit on Monday, it has to be in the bank by Thursday at 5, right? So you get it Monday, Tuesday's day 1, Wednesday, Thursday, 5. Okay. So let's look at an example. A sales associate received an earnest money deposit on Wednesday. The sales associate must deliver the deposit to the broker no later than Thursday at 5, right?
That's right.
So the broker must deposit in the escrow account no later than Monday if there's no holidays. Because if there's a holiday, it extends it, right? If there's a holiday in there, it'll extend out.
Mm-hmm.
So the way this works is Wednesday, the associate receives it. That's day 0. Thursday, they must deliver it to the broker. So Thursday's day 1. So even though the broker got it Thursday, the clock started on Wednesday when the sales associate got it.
Oh.
You have to know that. You're questioned on that. You may see a question about that on a test. An scenario and say, when's it due? So the day the associate receives it is the day 0. Now, the associate can give it to the broker the same day. Hey, I got this today, right?
Mm-hmm.
You don't have to wait till the next day. You want to give it to the broker right away. You don't want to be liable for that, right?
Yeah.
So it just gives you a day because of just life, you know?
Mm-hmm.
Or you get it 3 p.m. or something, right?
Yeah.
So it gets delivered to the broker Thursday. Friday would be day 2. Saturday and Sunday don't count. They're not business days. Monday, it must be deposited. Okay.
So this means that, like, in reality, that there's one business day for the sales associate, and then there's like 2 days for
Right.
the broker.
Right. Yeah. So it's 3 days in total, but day 1 starts when they get it. So,
okay.
But the thing is, the sales associate gives you the same day. It's still 3 days.
Yeah.
It doesn't count. Don't count from here. It's the day they received it to the day it got to go in.
Got it.
What happens in here, they must give it to you within a day or they're in violation.
Okay.
Okay. And this is only if the broker has an escrow account to take it, right? If you don't have an escrow account, you don't have to worry about this, right?
There we go.
That's reason 1.
Yeah.
Not that, right? Okay. Now, escrow checks payable to sales associates. Okay, that's not allowed. You got to instruct the buyer to write the check payable to the broker's escrow account. If a check is made out to the sales associate personally, have the buyer write a new check. The sales associate is not allowed to take money. There's no payment to that. It all goes to the broker. So sometimes customers will do that not knowing. So if it's not practical to ask them for a new check, you can write for deposit only and the name of the escrow account on the back of the check. And then you photocopy the check and endorsement and put it in the file. This is only when the broker has an escrow account. Okay.
Got it.
Postdated checks and is insufficient funds. You need to know this. Okay. If a buyer says, I want to make a $10,000 deposit, but you can't cash this till Friday, what do? You must obtain seller's approval before accepting it. If the seller says that's okay, we can do that, it's okay. The broker must secure the check until payable and immediately deposit in the escrow account. So if I get a check today for deposit, I got to lock it up, and Friday I must deposit it. If I don't do that, I'm in violation. I didn't follow my rule, right? Mm-hmm. So That's something, it can be done, but the seller has to approve it. Now, if a check, say I deposit the check on Friday, they told me to. I deposit it and the check bounces, there's insufficient funds. The broker is not responsible if the broker made a timely deposit. So if I kept my word and said, okay, Friday, put it in, and that check bounces, I'm not liable. I did what I was supposed to do and what the buyer agreed to and the seller. How can I know if that check was no good? I had no idea, right? I did what I was told.
Makes sense.
Okay. You need to know that. Okay. On the broker hold escrow accounts, the broker held escrow accounts, the broker must be a signatory on escrow accounts, no matter what. Additional persons, a bookkeeper may also be a signatory. Each account must be reconciled monthly. The broker must review, sign, and date monthly reconciliations. Okay, so there's real estate companies that aren't, the owners aren't the broker. So there's owners of companies, and then the broker is the qualified broker. That broker's responsible for all the accounts, not the owners. So if the owners do something weird, the broker can be in trouble.
Okay.
So that's an example of that. The broker must be the signatory. They can be, now you could have a bookkeeper be a signatory too. But however, if they do something wrong, who's responsible?
The broker.
Right. So if I had an escrow account, nobody would be signing that but me. Nothing would go out of that account unless I put it out of that account. You know?
Makes sense.
Now, interest-bearing accounts. Okay. The account can be interest-bearing, but you have to have written permission from all parties before placing it in an interest-bearing account. Written authorization must specify who is entitled to the interest earned. Broker, if agreed by all parties, may receive the interest. But there would have to be a document. Everybody would have to sign every time you put money in to do that.
What does interest bearing mean? What does it bearing mean?
That means the money sitting in there will receive interest from the bank.
Oh, okay.
Like a checking account might get 2%, like you might get interest, and then you have to say where that interest is going, and they would have to agree to it.
Got it.
Okay. And all this has to be itemized every month, and has to be balanced every month and signed off and filed, and has to be kept for the audits because they're going to audit you with this, right?
Mm-hmm.
So now you need to know this as well. Very important. Money to maintain escrow accounts. Okay. There's two types of escrow accounts. Okay. One is for sales and one is for property management. Okay. So when you're managing property, you have to have an escrow account because you have landlords, you have tenants, you have bills to fix, you have maintenance, and you got to pay bills out of it.
Mm-hmm.
Right? Because you're managing it. So the first type of account is a sales escrow account. When you sell a property, they want to put money in for deposit. The only time money goes in is for deposits, and the only time money goes out is for closings or return deposits if deals fall apart, right? That's the only type of transactions. Brokers may place $1,000 personal or business operating funds in a sales escrow account. So you may place up to $1,000 of your own money to keep a balance in there. So it's never negative. Brokers may place $5,000 personal or business operating funds in a property management escrow account. You got to remember $1,000 in the sales, $5,000 in management. The reason for that is if an air conditioner goes out and you need to get it replaced and you can't get a hold of the landlord, you got to have some funds in there that you can play with, right? That you can reimburse and then do things. So you're allowed to have $5,000 in the property management escrow, $1,000 in the personal. Okay. The money to maintain the account is not considered commingling. Commingling is illegal, and I'll explain that to you in a minute. Those funds are allowed to be there so you can they can help the account not go negative, and there's some play in there. Okay, it must be accounted for in the broker's monthly accounting record. So it has to be in that statement and balanced in the account every month and signed off on. That money you're leaving in there. Okay. So let's look at record keeping and retention. Brokers must keep business records, books, and accounts in compliance and available for DBPR audit. They must preserve the records for 5 years and 2 years beyond a court proceeding. So let's say you have a record for 4 years and a court proceeding comes up, you must keep it an additional 2 years after that.
Makes
But
sense.
if it's just records for 5 years, you keep them. I keep my records forever because they're digital now.
Yeah.
Years ago when they were paper, every time something would expire, you would shred it and get rid of it. You know, but everything's digital now. There's no point in getting rid of it, right?
Yeah.
So let's talk about mishandling of escrow funds, which is illegal. Okay, you have conversion. Conversion is the unauthorized use of another person's funds for property or funds or property for one's own use. Somebody gives you a deposit, you use the money to pay your electric bill. That's illegal. Conversion. Okay, so the broker transfers $1,000 from escrow account to the general business account to pay the office maintenance repairs. That's illegal. Okay. Broker may not use earnest money funds for their personal or business expenses. Trust funds must be kept in a separate account until the transaction is closed. Now you have commingling. This is to mix the money or personal property of another with the broker's own money or property. An example of this would be the broker receives an earnest money deposit of $5,000 for a pending transaction on a listing. The broker deposits it in a general operating account that are used to pay business expenses and commissions. So it wasn't put in the escrow account, it was put in the general account. Trust funds must be kept in a separate account until the transaction closes. This is a violation of license law. Okay. Now let's talk about failure to account or deliver. Let's say the licensee fails to deliver the money, the legal documents, or commission to a person entitled to receive it. Okay, the broker receives a check from a buyer made out to John Stetson Attorney Trust Account. The broker placed the check in his desk drawer with the intent to deliver it the next day to the attorney. The closing statement a month later shows that didn't show this earnest money from the buyer, and the attorney had no record of it. So the broker forgot to give the check to the attorney. That's a violation of law. Okay. Title company and attorney escrow accounts. This is what I use, just because I don't want any of that liability. All the things that's explained to you, the liability is not worth the aggravation to me.
I'm with you.
As a broker. Not all people think that, but me, I think that.
Yeah.
So a title company and attorney escrow account. Okay, this indicates the title company or attorney name, address, and telephone number of the contact on the contract. Within 10 business days after deposit is due, the buyer's broker must make written request to title company attorney for verification of receipt of deposit. Within 10 business days after the broker made written requests, they provide the seller's broker with a copy of written verification. Now, I call them and I get it within 3 days because we need to know. The law says 10 days. But when I have money going to the title company, I shoot them a message. I call them, hey, the wire was sent. Can you send me an escrow deposit letter? Because you need to give that to the other agent as well. They need to know the deposit was made so the contract's valid.
Got it.
Okay. Notice and settlement procedure. A broker must not disperse escrow funds until the transaction closes or with the agreement of the parties. So if a deal falls apart and the seller gets the money or the buyer, they have to sign an agreement to release the money, both parties. If there's a disagreement, they got to have a dispute resolution. And it's very clear, like if the seller gets a deposit, the buyer usually signs it because if not, they're going to get sued and they're going to have to pay more money. So, but sometimes buyers are spiteful and do that. They drag it out, So Chapter 475, Florida statute, provides a dispute resolution when there are conflicting demands between parties. So if a broker has an escrow account, there's a process they have to follow when there's a dispute, when the buyer and seller don't agree who gets the money if the deal falls apart. Does that make sense?
Yeah. So there's a process whenever that happens.
There's a process. Now, if the money's in an escrow account with an attorney or a title company, there is no process. You don't have any responsibility to that. That's now between the courts. They have to go to court for that. So I'll explain all this in a minute. Like we're gonna go through all that in a little bit. Okay. Now let's take a 5-minute break. We'll come back and I'm going to start going into that process with you. If something goes wrong, how it works, if the broker has an escrow account. For the test, for the state test, you need to know the process. It doesn't matter if the broker has an escrow account or not. You need to know how it works. Okay.
Yeah.
All right. So, okay. So let's take a 5-minute break and we'll come back at 11:13.
That's good.
I'm gonna pause the recording and I'll start it when we come back.
Awesome.
Okay, so welcome back from break, and we're going to continue on slide 36. So let's talk about when you have a deposit. Let's say you put a deal together and you have a deposit in escrow and it's in your broker's escrow account, right? Not the title company.
Okay.
Okay, there's something called good faith doubt. So if you're a broker and you're holding the money and you got a feeling that something's wrong, the buyer's going to do something, the seller's going to do something, it's called good faith doubt. That's when the broker doubts either party's intention to act in good faith according to the contract. You must notify the Florida Real Estate Commission within 15 business days of having that doubt. So if you just have a doubt, you're required to notify them. Okay. And you must begin a settlement procedure within 30 days of having that doubt. So when you got to document the doubt, and then you must start a settlement procedure within 30 days. Now, there's something called conflicting demands. This is when a buyer puts a deposit, the seller has it held in escrow, and the seller says, no, I'm keeping the deposit. You broke the contract. And the buyer says, no, I want my money back. You broke the contract. That's when they conflict. So that's when the seller says, give me the money, and the buyer says, give me the money. Now, no one can get the money unless they both sign who gets it. Or a court does it, right? Court forces it. So in this case, you must begin a settlement procedure within 30 business days of receiving the conflicting demands. And the time period runs concurrently. So if you notify them 15 days you notify them of the doubt, right? The good faith doubt. And then this happens, it coincides. So 30 days is from the 15 days. So that kind of runs together. Okay. It doesn't go, it's not 45 days, right?
Okay.
Okay. So go ahead.
Question. But wouldn't that be already like specified in the contract prior to signing?
Yes, but when they disagree about it,
Oh, I
it can be
see.
specified and the seller can be entitled to money. But the buyer doesn't, the buyer can say, I don't agree with you.
Gotcha.
They have to agree.
Okay.
Okay. So let's talk about the settlement procedure. The acronym for it is MAIL. You have mediation, arbitration, litigation, and you have an escrow disbursement disorder. Okay. So you can choose mediation. Mediation is informal. There's a neutral party involved, and it's a negotiated settlement. It can be negotiated and you all agree to it. And okay, this person gets this much, this person gets this much. You agree, you make a deal. Okay. Excuse me. Arbitration. Now, so mediation is negotiated. There's no determined outcome. It could work, it could not work, right? You negotiate. Arbitration, you have a binding judgment by a third party. So you have like a master or like a magistrate. Somebody's a third party, and they hear the case, and they make a determination. And whatever they go by, you have to go by. But arbitration has to be consented prior by the parties. So the buyer says, yes, I'll go by what they say. The seller goes, yes, I'll go by what they say. And then whatever they say, that's it. There's no argument.
No question.
So mediation is negotiation. Arbitration is set, right? But you have to agree prior that you're going to go by it. And if that's not what you do, you have litigation. Okay. There's an interpleader. And that means the broker has no financial claim. If it goes to litigation, the broker has no financial claim at all. Okay, there's a declaratory judgment, and the judge declares each party's rights to the funds. The judge is going to tell you, it's basically arbitration, but by a judge. It's going to a court case and fighting it, right? And the judge is going to decide. Okay. And now, escrow disbursement order. Okay, that's called an EDO. Okay, so what's an EDO? This is when the commission issues a determination of who is entitled to disputed funds. So if you put this into the state and the DBPR and you explain it to them, go ahead. You got a question?
Yes, on the last page, that was a quick transition, so I couldn't really.
Okay.
Yeah, that. On the litigation, the first bullet point right there that says interpleader. Can you expand on that a little bit? Like broker has not financial claim. I don't understand.
Yeah, the broker's involved in it because they're holding the money.
Okay.
However, there's no financial claim for them. An interpleader is just involved in it because they're holding the money.
Okay, so that means that they do not choose or gain any money from that?
Exactly. They don't choose, they don't gain, they're just involved in this settlement problem.
Okay.
You see,
Gotcha.
this is another reason not to have an escrow account. You got to go to court, you know, it's just for what? What's the benefit, right?
Yeah, interpleader is the role they're playing. So the interpleader is the broker.
Yeah.
All right. Wait, so in the other cases, does the broker gets paid?
Yes. So depending on the listing agreement, okay, this is negotiated. When you have a listing and you get a deposit, in the listing agreement, a broker can retain a percentage of the deposit because they're doing the work.
Gotcha. Makes sense.
So that's negotiated when you do your listing agreement. So
Gotcha.
if the deal falls apart and a deposit is kept, the broker can get some of that, and the seller gets some of it, and then you put it back on for sale. Because it's not the broker's fault that all the work was done. They did their job. They did the work. They got to be compensated. It's a reason to get compensated. Now, you can get nothing if you put nothing on the agreement. It's up to you. Like you can negotiate that with your clients. Okay.
Makes sense. Okay.
Yep. That's good. Makes sense.
Yes.
Okay, so let's talk about an escrow disbursement order. Okay. This is not these. This is a whole different area. This is when the department gets involved. So the commission, the Florida Real Estate Commission, will issue a determination of who is entitled to disputed funds. So you submit it all to them. They'll decide who is entitled. Okay. There's no EDO if the funds are in a title company or an attorney's escrow account. Okay. None of this process happens, this process for the EDO. You can still have arbitration and mediation if it's in escrow. But the EDO, with dealing with the department, the FREC, none of this happens if it's in a third party. Okay. Because then they just have to go to court and fight it. Okay. So again, there's no EDO if the funds are in a title company or an attorney's escrow account. Funds must be held in a brokerage escrow account to request an EDO. Okay. They must inform the Florida Real Estate Commission within 10 business days if a dispute is settled or it goes to court. So let's say you request an EDO. You're waiting to see who gets the money. And let's say they settle it. Say, look, we're just going to give the money back. No problem. You got 10 days to let them know. You got to know that number, 10 days to say they settled. Or if they say, you know what, we're not going to wait for the EDO. We're going to court. We're suing them. You have 10 days to let them know that too.
Okay.
Okay. Exceptions to notice and settlement procedures. Okay. There's 3 exceptions to this. Okay. First exception is a sale of a HUD owned property because that complies with the HUD contract. So none of this matters. The deposits and everything complies with the HUD contract, which is outside of this purview. There's a timely notice of right to cancel a residential condominium contract. So you have time to cancel after you get your documents and receive them. There's a 3-day period you have a right to cancel. If you cancel within that period, it automatically goes back. And failure to satisfy the financing clause. If a buyer is getting a mortgage and they have 45 days mortgage clause, so if the mortgage falls apart and they can't get it, if it's within that time period, they have 30 days, 45 days, whatever you choose. If it falls apart and they can't get a mortgage in that time, they have a right to cancel and get their money back. No questions asked. The inspection period, same thing, right? And I'll explain all that to you as we go. But these are the things you need to know for examination. If it's the timely right to cancel of a residential contract, condominium contract, if you have 3 days and you cancel in 2 days, they got to give you the money back. There's no agreement. It's just that's part of the contract, right? Failure to satisfy the financing clause, and if it's a HUD contract, it goes with that. Okay.
What was the HUD contract again?
Yep, that's a sale of a HUD owned property. That's the government owned property.
Oh, okay, right. What does HUD stand for?
It's the housing urban. Hey, HUD. Hold on a second. Hold on.
Yeah, I'm trying to build a glossary here.
Yep, that's okay. I got it in the things too. It's the department, the urban Department of Housing and Urban Development. Here it is, right here. Yep, it's a federal organization. We're gonna go deep in that.
Oh, okay.
So that's when it's one of their own properties. Okay.
Okay, thank you.
See, HUD is basically, they actually give incentives. They give tax breaks. They give tax benefits. They try to uplift communities. So they'll go into a community and try to, to uplift the community, like bring business in and things like that. And if it's a HUD owned property, there's a whole different contract process. Okay.
Got it.
Good. Okay, so we got that there. Good. Are you clear on that?
Partially. I will have to read it afterwards a little bit more.
We're gonna go into more detail on HUD. In my career, I very rarely dealt with HUD properties. In my career, I'll explain to you the process, and I have a system that we do with the brokerage if somebody deals with them. But I personally, there's only so much time in a day in the business, so you kind of stick. There's so many niches to go into.
Yeah,
kind of stick with what I do, So
I agree.
I mean, it's not hard to learn and do. It's a very profitable side of the business. There's only so much time in a day. It's not something I've practiced in.
Makes sense.
So let's talk now. We talked about the escrow account, right? When a broker has it and all the rules and everything.
Yep.
Now let's talk about a title company and an attorney as an escrow agent. Okay. Now you see all the liabilities, you see all the issues you could have if a broker has an escrow account, right? For sales. Now, when you do property management, you have to have one because you have to manage the properties, right?
Yeah.
But for the sales side, you see how many problems and liabilities and issues you can have. So a lot of brokers just choose to deal with a third party and not have any of those liabilities. So a broker is not obligated to report an escrow dispute to the FREC when it's in a third party. It's in a lawyer or a title company. You're not obligated to any of that. You're not obligated to institute a settlement procedure. So if they don't agree, you don't have to let them know within 10 days of your good faith doubt and all that, right? Remember we talked about that?
Yeah.
The title company or attorney will not disperse the funds without authorization from the parties to the transaction. So if they don't agree, they just got to go right to court. There's none of that in between. So you eliminate all that by having them put it in a title company, by having them put it in a lawyer, right?
Got it.
So you eliminate all that. Okay.
Question. So in the first one, it says broker is not obligated to report an escrow dispute to the FREC. Well, what is an escrow dispute?
Okay, an escrow dispute is when the buyer put the money in, and then to get the money back, they don't agree who gets it. The seller and the buyer. So if the buyer, it's when they dispute it's when they dispute the money in escrow.
Okay. So the escrow account company, the title company.
Title company or the lawyer, whoever's holding it.
Yeah, whoever's doing that, they will handle all of that, and FREC doesn't have to know.
And they're not allowed to give anybody that money unless they both agree. And then if they both don't agree, they gotta go to court and the judge will say who gets it.
Gotcha. Makes sense.
That's how that works. Eliminates everything else.
Yeah.
Now, rental information lists. I'm gonna go over this with you. However, this was supposed to come off the state test in January. This is no longer valid. However, when my students take the test, they call me and they tell me, hey, the test was like this. They'll give me a little bit of information. Tell me, oh, I remember, we did this. I remember this. And I ask them, if you see this question, And the last group that took the test still saw this question.
They saw it?
Right. So this is no longer taught in classes. However, it's still showing up on a state test. So I'm going to keep teaching it
Yeah.
until you tell me it's not on it.
Amen.
Because I don't want people to get on there and be like, oh my God, right?
Yeah.
So rental information lists. A long time ago, there used to be rental books, like rental booklets. You would go to a store and they'd be on the counter, free booklets. And you can make lists of rentals for people. And they would buy them, $20, $10, and they have a list and they look for apartments. So licensees who furnish rental information for a fee must provide a receipt with provision for repayment. Okay. So if somebody buys a rental list, they get 100% refund if the rental information is not current or is inaccurate. Well, do you know how fast rentals go on and off the market today with Zillow, like online?
Yeah.
A rental goes on the market and off the market twice in a day. Like, you know, so if you give somebody a book and they pay you, and I get in 20 minutes, it's out of date. You have to give them the money back.
Yeah.
Also, if the person buys the book from you and they do not find a rental, you got to give them 75% of the money back.
Holy.
Right? The refund must be requested within 30 days. So if they request it on the 31st day, you don't give them a refund. But if it's before 30 days, they have to give you the money back.
Got it.
Now, if you give somebody inaccurate rental information, it's the first-degree misdemeanor for selling out-of-date, inaccurate information. Well, if I print out a rental list right now and sold it to you 10 minutes from now, it'd be out of date because something changed. So do you see why this is no more?
Yeah.
But it's still, there's still questions about this on the test. They may say, you know, somebody came for a refund 45 days after. Well, automatically no refund, right? After 30 days.
Yeah.
You got to know if it's inaccurate, 75% refund. Right? Or no, I'm sorry. If they don't find one, they get 75%. You need to know that.
Yeah.
And if it's not accurate, they get 100% back. But within 30 days. That's what you need to know for this, okay?
Got it.
Okay, and misdemeanor, first-degree misdemeanor. You may see something on one of that.
Okay.
Okay, now let's talk about sales associate commissions and how commissions are paid. So sales associate commissions must be paid by the associate's employer, not directly by the buyer and seller, right? Because all money goes through the brokerage, right? So if you're doing a rental, if you're doing anything, you can't be paid directly. It has to come to the brokerage. The associate split is determined by the agreement with the employer. Every agent has an agreement contract with the employer. Associates may not operate independently. So, right, remember, a sales associate has to work under the supervision of a brokerage, active under a brokerage.
Or a building.
Or a developer.
That's what it is.
So associates may not operate independently. All the listings, contracts, and commissions are legally the property of the sales associate's employing broker. Okay? The broker has all the agreements and all the commissions and all the splits. And then once the broker receives the money, then their agreement with their agents takes over, and that's how they split with the agents. Does that make sense?
Yes. The broker is the one that does it, that handles all that.
Yep. Now let's talk about the broker's commission. Okay, it's established by agreement between the broker and the party who agrees to pay. And that's negotiable. There's no fixed rates. There's no fixed commission. There's no fixed listing fee. Everything is negotiable by law. It would be a crime. It'd be price fixing. It'd be an antitrust problem if you had a fixed rate. You can't do that. Okay. The state of Florida does not regulate commission rates or fees. No government agency does. Licensees may share their commissions with the buyer or seller in that transaction with full disclosure. So if you're representing a buyer and you want to give them $1,000 back towards their closing costs of your commission, you can do that. However, the seller has to agree to it and the buyer has to agree to it. You have to put that in an addendum or in the contract. As long as everybody agrees to it, you can do that. Okay. So does that make sense? Is that clear?
Yeah, it makes sense. Yeah,
I'm going to give you an example of that. So I had a listing and I had multiple offers on the listing and I had a contract on it and we had other offers that were coming and we took one contract. Well, after the inspection, they wanted a $5,000 credit. The commission I was making was like 15 grand. I was going to make 15. The other guy was going to make 15. Well, I had other offers that were cash offers ready to close. It was an investment property. And I was going to make 15 grand no matter what. If this guy bought it or if this guy didn't buy it and I sold it to the next one, I'm still going to make 15 grand, right?
Yep.
So the seller wanted a $5,000 or the buyer wanted a $5,000 credit for something. Well, the agent wanted me to give 2,500 and they wanted to give 2,500. So we would both make 12.5 and then the seller would get the buyer would get the 5,000. Well, I told the agent no. I said, look, I have backup offers. If you don't buy this, I'm going to sell it to that guy. He's going to close in 15 days cash and I'm still going to get my full commission. So why would I give you $2,500 of my money?
Amen.
That agent decided to give a $5,000 credit to his buyer. He got 10,000. So I got my 15. He got 10 and 5 went to the buyer because he didn't want to lose the 10.
Gotcha.
Right? So that's just the way it goes. Now I could have said yeah and done it, but I didn't want to, right? Why would I do that? I'm not gonna It's not my problem.
Price, yeah.
Right. So that's how that works. Now, does that make sense? Now what happens is in that case, we had to do an addendum. And it says buyer and seller agree that the selling agent for the buyer will be crediting the buyer $5,000 of his commission. And then we had to sign that. The seller or the buyer had to sign it, and it went in the contract. And it had to go to the title company. That's how you notify them. So you can give buyer and seller part of the commission. You know why?
So you cannot?
No, you can. You can. Like, do you know why you can? Because remember, you can't give commission to people. It's illegal, right?
Yeah.
Unless they're licensed, right?
Yeah.
But do you remember why you can give it to the buyer or seller?
Because they are the owner of the property, like they're
on the deed. They're on the contract.
Yeah, they're on the contract.
If you own your own property, you can do that.
Nice.
With everybody knowing. But if you're not on the contract, you couldn't do that.
Nice.
Right? So that I want you to remember that concept for when you questions, because the questions make you think about things like that.
Yeah.
Okay.
Surprised I remember, but I did.
Yeah, you did. See? Yeah, you did. But that's what it is. You did good with that. Good.
Nice.
All right. So let's look at the antitrust laws. Right now, there's lawsuits going on. There's huge lawsuits going on. A couple of them settled. They're starting next month. The DOJ is suing NAR, and there's sellers suing for antitrust. If this gets settled and they lose, it's going to change the way the real estate industry operates for 100 years. It's going to change everything. How buyer agents get paid. I don't want to go into too much detail now with that because we're doing this. We don't have time for that. But on YouTube, I have videos. There's a section. There's going to be a 5-part series. There's 2 done. It goes over the exact lawsuit and everything that's going on. I have a background of it, and I actually go through the whole case. So if you want, you can check that out. It talks all about this. So we're going to go into details here. What I'm teaching here may change because the laws may change as we speak, as that happens. So antitrust laws protect competition and ensure against restraint of the trade. The Sherman and Clayton Antitrust Acts. The Sherman Act is what these lawsuits are about. And then you have the Federal Trade Commission Act. Okay, it is illegal to fix commissions or fees for services. It's called price fixing. You cannot say our brokerage charges 6%. The rate for listing is 6%. That's breaking the law. You can't fix rates. It's price fixing. You cannot conspire to split up market areas to avoid competition. That's called market allocation. That's like 4 brokers getting together and splitting up the town. And you say, you work here, you work here, you work here, you work here. We won't bother each other. That's called market allocation. Those four brokers getting together saying, listen, let's charge 7% and nobody charge anything different. That's fixing commissions. That's price fixing. Does that make sense?
Gotcha.
Cannot do that.
And what's the percentage right now?
Whatever is negotiated.
Oh, okay.
You can't. There is no percentage. There's no fixed percentage.
What do you normally charge?
It depends on the deal. Sometimes I charge between 4% and 6%. Depends on the deal. Depends on what services they want.
Gotcha.
Right. So if they want all my advertising services, everything I do, it's 6%. If they want less advertising, less marketing, I'll do 5% or 4%. Like it depends. It just depends. Okay. I give them options. I have options of what I do for them. If you want this, is this much. If you want this, is this much. If you want this, is this much.
And yeah, there really is no normally charge, right? Like there's not something you normally charge.
You can't. No, you can't do that would be price fixing.
Oh, okay.
Answering that question is price fixing.
Okay, gotcha.
Yep. Okay. So let's talk about lien on residential property for unpaid commissions. So let's say a deal's done and then the seller doesn't want to pay the commission at closing. Or liens where you're doing a commercial property or you're selling a property and it's a very big property and it's a multi-million-dollar commission. A broker can put a lien on the property for the commission. A lien on the profit. So they're guaranteed. They can't argue and fight it. When you do a big deal like that, people do stupid things, right? Mm-hmm. So something called, you could put liens on residential property for unpaid commissions. So only brokers, not associates, can seek this compensation from buyers or sellers, right? Because the broker is the agreement, not the associate. The associate is representing the broker, right?
Yeah.
Only brokers, not associates, can seek this. Okay, liens on residential property for non-payment of commission. Okay, it's only allowed if the broker is given the authority in the listing contract. So in the listing agreement, you have to have in there that you're able to put a lien on the property for your commission. And they have to agree to it. Otherwise, you must seek a civil judgment. If they don't pay you, you got to take them to court. Take your contract, say, hey, they didn't pay me, and sue them. Okay? The lien may not encumber the title to the property. So the reason for that is if somebody buys a property from a seller, the seller doesn't want to pay the commission. You can't put the lien on the property because the buyer won't be able to buy it because there'll be a lien will not let it be clear title. So you can't tie up the property for the buyer. That would be a voided contract for that. You have to go through civil and you have to put the lien on either the profit of it or another situation. So the lien cannot encumber the title of the property at stake. Does that make sense?
Not so much. Like I'm trying to grasp the idea, but not just yet.
So if you have a listing to sell property A, and your commission is going to be $100,000, and you in the sale and the listing agreement, you have an agreement with the seller. I'm going to put a lien against you for the $100,000, and when you pay me, the lien goes away. The lien can be put on the profit. The lien can be put on another property. The lien can be put on a bank account. The lien can be put on anything but property A. Because if the lien is put on property A, there will not be clear title for the buyer to buy it.
Makes sense.
Does that make sense now?
Makes sense.
So it can't encumber the title to the property.
So basically, the lien has to be put in another asset. That's not the house itself.
Another asset, unsecured, but that doesn't help you. But you got to put it on something.
Yeah.
Right? So that's how that works. You can't put it on the actual property because if something they can't clear their lien till you're paid, and you can't get paid till you close, right?
Yeah. So it's gonna be impossible there.
Yep. Now let's talk about remember part 475 Florida statute. Part 1 was brokerages and schools. Part 2 is appraisers. Part 3 is real estate commission lien, and then part 4 is lease lien on commercial. Remember?
Yeah, we talked about that.
This is going to be on part 3. Okay, the commission lien for commercial. Okay, this gives the broker lien rights on seller's net proceeds from the sale of a commercial property. You're selling a strip mall, $30 million. Your commission is going to be, $300,000. you can put a lien on the proceeds that the seller's getting, not the property. Remember, because you can't sell the property if there's a lien on it, right?
Yeah.
So you can put this part of this chapter explains this, and this in part 3, it talks about putting the lien on the proceeds of the seller's commercial property. There's not a lien right on the property, like we talked about why, right? The brokerage agreement, which is the listing of contract, must clearly state the broker's lien rights, that they're putting a lien on the property. You have to have that in the agreement. If that's not in the agreement, you cannot put lien rights. Okay.
Well, what does it mean by proceeds? Could you use another word for that maybe?
That's the profit. Proceeds are the profit.
Oh, the profits.
Okay. If they're selling it for 30 million, they owe 10 million, they're getting 20 million. You would put the lien on that 20 million for your 300,000. So that 300,000 would come to you directly from the profit before going to the seller.
Gotcha.
So proceeds is what you're making, the profit.
Okay.
Okay. Now let's look at the part 4. This is on a leasing commission. Okay. Now on this, it gives the broker the lien rights for the commission earned from leasing a commercial real estate property. If the landlord agrees to pay commission, the lien is against the landlord's interest in the property on a lease. See, on a lease, they're not selling the property. The title doesn't change. So in this case, you would put the lien on the property. So if they don't pay your commission, you got a lien on the property. Because that's not changing, right? The buyer's not getting it. The buyer's just getting a leasehold. They're taking a term, right? They're not taking the deed. We're going to talk more about that in a little bit, about title and transfer and stuff.
All right.
Now, if a tenant agreed to pay a commission, the lien is on the tenant's leasehold estate. So sometimes in a commercial deal, the tenant who's moving in pays the commission, right? So sometimes the landlord doesn't pay it. Sometimes the tenant pays. Sometimes they both pay. So if a tenant agrees, it goes against their leasehold estate. The money they're paying to rent it, it comes off of that. You put the lien there. On the landlord, it goes on the property. Does that make sense?
Yep, it makes sense.
Okay, good. Kickbacks. Kickbacks is an unearned fee paid to a licensee associate with a real estate transaction for non-real estate services. Referral fees for non-real estate services are the following. The buyer and seller must be fully informed. It must not violate RESPA, which is the Real Estate Settlement Procedures Act, which we're going to go over in a bit.
Okay.
You cannot pay an unearned fee associated with closing services. That's RESPA. Person receiving the kickback must be properly licensed if applicable. A mortgage loan originator license, another real estate, like you're given a referral fee. They must be licensed. You can't give somebody a fee if they're not licensed. So kickbacks aren't necessarily illegal if everybody's informed. It's illegal if you don't tell them, right? So, and it can't violate law. It can't violate RESPA. It has to be within the law and everybody has to agree.
Could you give me an example of that?
Sure. Let's say, let me see. Let me think of how I could, see, real estate. Okay, so if you have another agent that recommended you somebody, and they send you a client and you sell the deal, and you want to do an agreement, give them 25% of the commission, right? Mm-hmm. So I have a woman in Texas that recommended me somebody to sell their house here. Her niece. I'm selling the house. When I sell it, I'm going to give her 25% of the commission. She's licensed in Texas. I have to send the money to her broker and then they'll split their money. Technically, that's a referral fee / kickback because we're all aware of it. There's an agreement on paper.
There you go.
Example of that.
Nice. Thank you.
Is that cool?
Yeah.
Okay, good. Now let's look at referral fees for real estate services. This is going to talk about what I just talked about. Licensee may share their commissions with the buyer or seller in the transaction with full disclosure. That's like I just told you about, right? That deal where the kid gave some of the commission. I didn't give any of mine.
Yeah.
That's an example of that. Buyer and seller agreed, boom, done. They may not share the commission with an unlicensed person other than the buyer or seller. We just talked about that, right?
Yep.
They may not pay an unlicensed person for referral of real estate business at all, except the one exception was the finder's fee up to $50 for a tenant. Remember, if you rent an apartment complex and you tell all the tenants, hey, I have 3 units. If you rent them out, I'll give you $50.
Yep, no more than that.
That's the only time that's allowed. Cannot do it any other time.
Got it.
Okay. So let's take a 10-minute break. We'll come back and we're going to talk about brokerage business entities, how brokerages are set up, LLCs, corporations, things like that. So let's come back at 12:08. I'm going to pause it and we'll come back. Okay.
All right. See ya.
Yep. See you in a minute. Okay. So now we're going to start talking about the brokerage business entities. So chapter 475 of the Florida statute defines broker to include anyone who is a general partner, officer, or director of a brokerage partnership or corporation. Chapter 475 prohibits a person licensed as a sales associate or a broker associate from registering as a general partner, officer, or director of a brokerage entity. So basically, a sales associate and a broker associate cannot be an owner of a real estate company. You either got to be a broker or have no license to be an owner of this types of businesses. Okay. So what are the business entities that may register as real estate brokers? You could be a sole proprietorship, a general partnership, a limited partnership, a limited liability partnership, a corporation, and a limited liability company. Okay, so that's your choices. Now let's go over each one. A sole proprietorship is owned by one person. The owner has full liability. The owner must hold an active broker license, and it can be registered under their own name or a trade name. They can do a DBA, right? That was like the first sign I showed you. Remember Mo's Real Estate, whatever, and it can be licensed or LIC period real estate broker, right? Remember when it was sole proprietorship or a DBA? Now, the other sign where it has to have the company name, the broker's full name, licensed real estate broker, this is where that starts, with a general partnership. So this is where 2 or more persons are engaging in business together. It's created by a written, oral, or implied agreement. Each is liable for the partnership debts and can bind other partners in contracts. So if you do an advertising contract, you're binding the other partner to it in a general partnership. A real estate brokerage general partnership must register the partnership with the DBPR. At least one partner must be an active broker. Partners who deal with the public and perform real estate services must be active brokers. Sales associates may not be general partners. So you can have a partner that's not licensed. They can be a money partner. They can handle marketing, advertise, training of agents, sales, things like that. But they cannot deal with the public without a real estate license, right?
Got it.
Class 3 felony, 5 years or $5,000, right? If they do that. Now you have a limited partnership. This is created by a written instrument filed with the Department of State, which is Sunbiz. One or more general partners and one or more general partners and one or more limited partners. Okay. So general partners are exactly what general partners were explained before. Limited partners make investment of cash or property, but not services. Limited partners have limited liability. So, when you're doing a real estate investment, you have general partners who operate it and limited partners put money in and get money out, right? But they don't do anything with the business. Okay. An example of that. Now let's look at a real estate brokerage limited partnership. It must be they must register limited partnerships with the DBPR. General partners who perform real estate services must be active brokers. At least one general partner must be an active broker. You got to have one. all other general partners must register with the DBPR. We talked a little bit about that. So if you're licensed and a qualifying broker, you're already licensed with the DBPR. But if there's 3 partners who aren't licensed, they need to know who they are. They must register.
Got it.
Sales associates may not be general partners. However, they may be limited partners. Limited partners are just investors. They put money in, they get money out. They have no say in the operation of the business. Okay. Limited partners do not register with the DBPR. Only general. Okay. Let's look at a limited liability partnership. Okay. There's protection from personal liability. Partners are not subject to limitations imposed or limited partners or in a traditional limited partnership. Name of registered limited liability partnership must include in the name of the company. It must be registered limited liability partnership or LLP at the end of the name. So if the name of the company is ABC Realty, it has to be ABC Realty LLP or ABC Realty Limited Liability Partnership. It has to be in the name. Okay. Let's look at corporations. Okay, a corporation is an artificial person or legal entity created by law. You file articles of incorporation with the Florida Department of State. Foreign corporation is organized under laws of another state, may do business in Florida. So a foreign corporation isn't a foreign corporation from another country. If you're in Florida and the company's from Georgia, that's a foreign corporation registering here. Like my brokerage in Florida is a foreign in Tennessee, right? I'm here in Florida, but I'm licensed in Tennessee. Does that make sense? Not in a corporation, but the concept, right?
Yeah.
Okay. Domestic corporation is incorporated in Florida. So if they're in Florida, they're doing business in Florida, that's called domestic. Okay. It's managed by a board of directors and officers, and it may be for profit or nonprofit. Okay. Rolex Watch Company is a nonprofit company. Did you know that?
Say that again.
Rolex watches.
Mm-hmm.
They're a nonprofit company.
I did not know that. No.
It's not that they don't make profit. They pay everybody the money. There's no profit left, but they're actually a nonprofit company.
That's insane because those watches are not cheap.
Yep. So real estate brokerage corporations, they must register the corporation with the DBPR. At least one officer or director must be an active broker. Active and inactive brokers and unlicensed people may serve as officers and directors. So active, inactive brokers and unlicensed people may serve as officers and directors. No sales associates, right? They must be active brokers to perform real estate services. See, they repeat that a lot, right? You got to be active to do services, right? Unlicensed officers and directors register with the DBPR. We talked about that a couple times, right? They all have to do that. Sales associates may not be an officer or director. Sales associates may be a shareholder. So they can own stock, but they cannot be an officer or director.
Got it.
Limited liability company, LLC. It's the best features of a corporation and a partnership. So you have protection from personal liability, and the IRS treats the LLC as a partnership for tax purposes. So your income is only taxed once as a partnership. Because when you're a corporation, you're taxed as the money comes in, and you're taxed when you pay it out. Like you're taxed twice. So in a limited liability partnership, you don't get that. You get taxed once, and you're treated as a partnership. The money flows right through to the owners without payroll. You do a 1099, or you can do it, at the end of the year, you have the profit. It's one return.
Gotcha. Could you explain that part one more time as to like the difference between like paying once and then paying multiple times?
Yeah. So when a corporation makes profit, they're taxed as a corporate profit. There's corporate tax rate. It's higher than a partnership tax rate. So a corporate, you got to pay when you bring money in, you got to pay money on the profit coming in. Then when you pay it out, you got to pay, like you pay your Social Security, your income, all your taxes when it comes in. Then when you pay yourself a salary, you pay that tax again on your salary. So you're paying twice on your taxes as a corporation. Limited liability company, no. You basically are partners. Your tax is the partnership. So you pay taxes once when you take your money out. The income's not taxed.
Okay.
Yeah. Now let's talk about vacancies in office. Okay, if the only active broker of a brokerage entity dies, resigns, or is unexpectedly unable to remain as active broker, the vacancy must be filled within 14 calendar days. During that time, no new brokerage business may be conducted until a new active broker is registered with the DBPR. So if you're working on deals and you're working on deals already done, you can continue that, but you cannot take a new client in or write a new contract or new listing agreement until that's replaced. Failure to timely replace a broker results in cancellation of the registration and licensees become involuntary inactive. So if they don't replace them, the company's shut down and every agent there becomes involuntary inactive automatically.
Got it.
Okay. Now, there's something called a temporary broker. Vacancy of office may be filled with a temporary broker. They must be registered with the DBPR. There can be a temporary broker for up to 60 days without need to comply with the Florida Department of State registration requirements. Failure to appoint an active broker or temporary broker within that 14-day deadline results in automatic cancellation of the brokerage's DBPR registration. Basically, the company's gone. Okay. Now let's look at business entities that may not register as brokerages with the DBPR. Ostensible partnerships, quasi-partnerships. That's basically if people hang around together and just people assume they do business together, but there's no legal documents. You cannot have that. That doesn't exist. Corporation sole. These are nonprofit religious entities. You want to remember that one. A corporation sole is a church. A church cannot be a brokerage. A corporation sole, religious, is for nonprofit religious entities. Okay. Joint ventures. These are temporary business arrangements. Let's say broker A and broker B are teaming up to sell a development. That cannot be registered as with a brokerage. That is two separate companies just doing like a joint venture. They're not a new company. Business trusts. That means a trust set up for your business. It involves the entity's own property. That's unlicensable. That can't be registered. Cooperative associations, corporate owned property, co-op units do not register. And unincorporated associations. An example is like a property owners in a subdivision. The associations do not register. Okay, they may not register any of those. So let's look at trade names. These are also called fictitious names. Business name other than the legal name of the person doing business. TAs, trading as, DBA, doing business as. Fictitious name refers to the name registered with the Department of State. Brokers who operate under trade names must also register the trade name with the DBPR. Associates must have licenses issued in their legal names, not under the trade name. Okay. Like, for example, Pier 21 LLC has a DBA, the Florida Real Estate School by Pier 21 Realty. So Pier 21 Realty files a fictitious name and owns that. Then when I file for my license for my real estate school, my license is Pier 21 Realty, DBA, the Florida Real Estate School by Pier 21 Realty. That's how my license says for the school. I keep it all together because it's all one tax return. It's all one business. There's no reason to have separate businesses. It's all under one umbrella. Okay. That's where that would be used. Or remember that sign I showed you, Mo's Realty? Remember, Mo, that's a fictitious name. They put that, bought the name, filed it as that. And that's why it's on the sign.
Gotcha.
That's where that comes in. Okay, forming a professional association in an associate's legal name. So when you're a real estate agent, it's your name. And then, you're just in business for yourself. Now you can set yourself up as an LLC or a corporation or a professional corporation. The reason you would do that is so you don't get double taxed. You would do that so you could set up as a company, not as a person, and you don't have to pay double Social Security and things like that. Real estate agents, once they do so many deals and make so much a year, this is very profitable. It saves them 18% almost. So if they make $200,000, they're saving $36,000 in taxes. So when you start making money to that level, and when you start closing a certain amount of deals, it's worth doing this. So let me explain how this works. I used to do this before I was a brokerage. When you're a brokerage and a broker, you can no longer do this. You can only do one or the other. Because as a broker, I'm an LLC, right? So there's no reason to do this. But as an agent, you would do this to get those same tax benefits. So a sales associate and broker associate may organize themselves into a type of professional association in their legal name only. You can't be ABC Realty. It has to be your exact full name, comma LLC or comma PA or comma PLLC. You can't, it has to be your name as your license. And what you would do is you would file that with the IRS. You would get an EIN number, set it all up, and then you would send that to the state. The state will send you a new license with your correct name with the end on it. And then that's how that would work. If you ever change it back, you would change it back. There's paperwork to do it. Or when I changed it, it went from a PA to being a qualifying broker, and the other one disappeared. It ended. Okay, so you have to register with the Department of State. Then you register it with the IRS, and then you send it all to the DBPR. You send them the proof of the Department of State, EIN, all the information, and then it can be issued in the sales associate's name with the professional designation, PA, LLC, or PLLC. And I always recommend if you do it, do PA because it's a prestigious one. Only engineers, attorneys, and real estate agents use PA. So if you do, you could do LLC too. It's whatever you prefer. But then when you advertise, that has to go on your business cards, all your advertisements, just like your license, the way it states. So it'd be like your name as your license, PA. Okay. That's how that gets set up. That's not something to worry about now. And eventually it's very easy to set. There's title companies and lawyers that have classes. They show you how to do it. And then they charge you a few $100 and they do it for you. But you can do it yourself too. It's not hard, but it just depends. Like if you want to find out all the details, do one of them, check it out. And then you can do it yourself anyway.
Yep.
Now, personal assistants. This is what we're talking about, right? So you could have an unlicensed assistant. When they're unlicensed, they can do administrative and clerical tasks. They may not perform the duties requiring a license. They can't talk to clients about deals. They can't negotiate. They can't show property, right? They may not be paid a commission. So they can't get commissions if they're not licensed. Licensee who employs unlicensed assistants must comply with state and federal employment laws. They got to be put on W-2. They got to pay Social Security, Medicare, withholdings, things like that. Now, if they're licensed, they can perform real estate services. That's why licensed, right? They must be registered with the employing broker. So whoever broker they're working for, they got to be licensed with. The broker must pay licensed assistant for brokerage activities. So if say you're an assistant for an agent, the agent cannot pay you. The broker has to pay you. Because you can only be paid by the broker, right?
Yeah.
That's the way it works. Okay. This way they can, but it's a W-2. It's not licensed. But because they're licensed, they can only be paid by the broker.
Makes sense.
Okay. And that's the end of the contract section.